Corey, are you going to talk about hockey tonight, or are you
Not
going to
very
talk
much.
about Canadian
I'll talk about patents and trademarks instead of hockey. But my poll question, actually, not so much about whether somebody's filed a patent or trademark application in Canada. My poll question last night was what hockey team did people cheer for? But I'm happy to thank you all for braving the snow out there tonight and coming to try and learn a little bit with us here tonight. My job is to try in the next 10 minutes or so to tell you a little bit about the business climate and the legal environment in Canada, I think, that would lead you to consider whether or not there's a spot to fit in your business plan for protecting your IP in Canada. Unlike my colleagues, coming from regions, to give you a flavor for the size of the country, it's maybe a tenth the size of the U.S. Canada's only 35 million people. But something like 45% of the players in the NHL come from Canada. So we got a lot of good hockey players up there, and it's a good business climate. So I'll tell you, geographic proximity is one of the reasons. You all know where we are. We're not so far away. In fact, lots of you have probably been there, and I thank you for coming there and spend as much of your money all you want. But in terms of doing business in Canada, geographic proximity and the similarities in the language and both the personal and the business culture, I think, are a couple of the reasons why I think a lot of your businesses might contemplate. You might be contemplating fairly early in your market expansion or your market build-out strategy being on the ground in the Canadian marketplace. Our culture is so similar. Barry from Australia and I were comparing notes last night that I think I'm ashamed to admit I think I actually watch more American TV than I watch Canadian TV at home. So in terms of branding and in terms of the presence of your brands and your products in the market, even in terms of spillover advertising and those types of things, you're in the market there regardless. Consumers in Canada like a lot of the same things. I mean, really, it's very compatible and parallel culture, I think, on many levels. And we have a long and large trading relationship between our countries. In my province, where I'm from in Saskatchewan, for sure, sales to the United States are the highest. Are the highest export, and we thank you for buying all our oil and all as much of our potash as you can. But in Canada in general, we value our trading relationship with the United States. You're our largest trading partner, and I was going to look up today. I don't know that U.S. to Canada trade is maybe at the top of your list, but I think it's up there. So again, I think it's a place that probably figures fairly high in. It's probably an easy market for you in a lot of ways too to consider expanding to. The final reason why I'd suggest to you that from a business climate perspective, beyond the fact that it's a reasonably compatible, even a legal and startup business environment. Also, you've got a very favorable currency right now. In the last 6 or 8 months, again, you're getting about a 25 or 30% premium on your currency. So if your business is actually physically going to expand into the Canadian marketplace, or you just want to come on a vacation, you're going to get about a 30%, 25-30% premium on your money. And so if you're actually contemplating putting some assets on the ground there, it's a buying opportunity. So many companies, I think, find Canada early in their marketing plans, even if you're not going there yourself, you might more easily find a distributor or a licensee or something there. This is a good reason, I think, to consider filing applications to protect your IP rights in Canada, probably earlier in the process than not. I thought I would just talk for about 20 seconds apiece on some of the similarities or differences between the different legal regimes, the contract regime and the patent regime and those types of things. Contract law in Canada, frankly, I'm not going to bore you too much with contract law because I don't think there's too many lawyers in the audience and nobody else finds it really all that interesting. But from a contract law perspective, the principles, we have a common law system in Canada and the contract law is very similar. So you're going to find your U.S. counsel is probably going to go and get some local help, but you're going to be able to really follow along and easily extend your contractual relationships using a lot of similar language and things. So in terms of non-disclosure agreements, distribution, licensing agreements, trade secrecy agreements and trade secret programs, similar principles, very compatible and easy to sort of give your counsel the direction and to work in your company into sort of expanding in that direction. In terms of our patent system, the test for patent infringement in Canada is pretty similar. There's really only a couple standouts, sort of one exception and one similarity I'd now mention. In terms of if some of you folks are in the biotech space, there's a prohibition on patentability of methods of medical treatment in Canada, unlike there is in the States. So this doesn't mean you're dead in the water, but it just means potentially you need to do a little bit of work to either work around that, or sometimes you can claim around it and work with your local council. But it's one thing that kind of factors into your plan. So if you're in the software industry, software I would say now is more reasonably considered protectable in terms of patents as well as in terms of copyright in Canada versus where we were a number of years ago. On the public disclosure grace period point, our law is very similar to that of the U.S. There's a 12-month grace period once you disclose your invention. There's a slight difference in what constitutes a disclosure. So, but the 12-month period is there. And beyond that, we are actually also a signatory to the patent prosecution highway piece that Mindy mentioned, which works really well, actually. So you can, again, it makes it pretty cheap and pretty easy to follow on with Canadian protection, particularly if you've already done your U.S. case. The trademark system, we currently have a use-based system like you have in the U.S. here. I won't say anything more than to say, basically, we right now have a system very similar to the U.S. on the trademark side. There's a major set of amendments being made in the trademark law right now, which I would just summarize by saying we're going to end up with a system that looks a lot more like the European system at the end of the day. I'm happy to bore any of you to tears later to talk offline about that, but major changes coming in our Trademark Act. The current term of a trademark, you register there for 15 years and it's renewable. Some of you might have heard about the Madrid Protocol, which is an international trademark treaty, which does not yet apply in Canada. These amendments that are coming, a part of that is to get that in place. My understanding now is that it's kind of all on hold a little while because they decided they have to replace the computer system at the trademark office in Canada or something to get there, but they'll get there soon. So why you would search and file your rights in Canada? I think, like I said, a lot of companies do cross-border business. It's good to create your right or to protect your rights now and have them in place. I think as your market develops, cost-wise, it's reasonably cost-effective to protect your rights in Canada. It's just easier to enforce there with registrations and to have some notice in the record if you're wanting to sort of put third parties on notice. One of the things that this is a point that's equally applicable down the table here. I think as you're making your market plans outside the U.S., I think it's a good thing to remember contemplating clearing and searching your rights in other jurisdictions. Patent-wise, there's global novelty requirement, and frankly, you're probably going to catch a lot of that when you're doing a patent search anyways. Everybody likes a good war story, whether it's one with a good outcome or a bad outcome. In terms of trademark, on the trademark and branding front, the story that I often use as a good example of some of the issues that can come up. I had a client a number of years ago, a multinational corporation who were rebranding their company, which, I mean, it's nirvana for a trademark lawyer because there's just all kinds of work to do. But first thing we do is we get on the phone with the marketing people and they say, here's the 4 or 5 new trademarks we want to think about using. What they don't tell you is they've already picked the one they want and they've already done half the work before you've actually cleared it. But so we did a search. And we identified, look, this is the one, I know this is the one that all the way up to the top chair, they want this mark. But there's 3 or 4 little things, abandoned little thing over here, a little mom and pop shop that looks like it doesn't exist over here anymore. And client, my job is to give the client the information. They can make the decision they want. And in this case, the CEO said, damn the torpedoes, let's go. And we'll deal with the problems if they come up. 3 years and about $7.5 million later, they have their trademark free and clear, and now they're thinking about rebranding again. But that's so you can try to avoid some of those headaches by engaging with your counsel early, and I think it's good to engage in searching. Like in a lot of cases, I'll have clients who will search specifically in Canada and in the U.S. at the same time because the markets are so close together that even in terms of giving yourself ultimate comfort in your own market, you might want to identify spillover from Canada. anti-counterfeiting mechanism, which we now have in Canada. This is another reason why you might contemplate filing your rights there. Whether you're one of the reasons you might use that is you potentially have a distribution arrangement in place, either yourselves or with a third party in Canada. And if you want to be able to take the benefit, we don't have like the ITC. I don't know if any of you have ever experienced anything with the ITC in the States here, or the Customs and Border Enforcement mechanism that you have in the States. We haven't until now had this in Canada, which has made it very hard to keep counterfeits out of Canada because the system has not been it hasn't been really user-friendly for rights holders. So it's doable, but kind of a lot of work. There's a new system which is just getting its legs under it now, which is based upon registration. So that's another reason why you may want to contemplate registering. Magnitude of cost to protect your trademarks or patents or things in Canada. You know, to protect a trademark, I typically tell clients to budget $1,200 to $1,800 maybe from start to finish to do a Canadian registration. It's cheap insurance, frankly. And particularly on the patent side, again, if we can follow along behind your U.S. Patent Counsel, who's frankly done most of the heavy lifting for us already, you're looking at a matter of a few $1,000s to protect your patents also in the Canadian market. The only last point that sometimes I have, particularly with American clients, and we were telling some stories here before about, particularly like for James or for people from other markets, with in other languages, localization and translation and things become issues. Lots of my American clients don't really like having to translate their trademarks into French. And if you register your mark in French in Canada, there's a rule which you can avoid the nasty gram from the Quebec language police when they tell you you have to translate your trademark if it's registered. So that's just one other little reason where if you don't want to have to parallel brand something to ship it into a tiny little corner of the market, you can do that. I'm going to stop right there. I'm happy to chat afterwards and answer any questions, and thanks very much.
All right, Corey, thank you. Awesome, awesome.